Today, we're cracking open the rulebook that governs every single thing you hear in a federal courtroom. It's called the Federal Rules of Evidence. And honestly, if you want to understand our justice system, you've got to understand this. So let's jump right in.
We've all seen it, right? Some big courtroom movie. A lawyer jumps to their feet and shouts, "Objection." But have you ever stopped to wonder what they're actually objecting to? What are these invisible rules that create all that drama?
Well, it turns out all that supposed chaos, it isn't chaos at all. Behind every single objection, there's a rule. Every piece of testimony, every document, it's all being filtered through this complex and kind of fascinating rulebook. And this is it, the Federal Rules of Evidence. Now, the best way to wrap your head around them is to think of it like this. Every piece of information has to run a gauntlet. It's got to pass through a whole series of gates before it's allowed into the trial. And today, we're going to walk through that gauntlet together. Okay, so the very first gate that any potential evidence has to get through is relevance. It's super simple, really. If the information isn't relevant to the case, it goes no further. It's the most basic test of all. So what does all that legal jargon actually mean? In plain English, the information has to matter. Does it make an important fact in the case even a tiny bit more or less likely to be true? If the answer is yes, it's relevant. That's it. You know, there's this classic legal saying that explains this perfectly. A brick is not a wall. See, a single piece of evidence doesn't have to prove the entire case all by itself. It just has to be one brick in the wall of the argument. And if it's one brick, it gets through that first gate. So our piece of evidence made it past gate 1. It's relevant. But the gauntlet isn't over, not by a long shot. Next up is the fairness gate. Because even really relevant information can get thrown out if it's more about confusing or inflaming a jury than actually proving a fact. This is Rule 403, and it basically puts a really powerful tool into the judge's hands. They have to weigh two things. How much does this evidence actually help prove something versus the risk that it's just going to stir up the jury's emotions or, frankly, waste everyone's time? It's a really critical balancing act. And here's that balancing act in action. On one side of the scale, you have the probative value. How useful is it? How much does it help prove a fact? On the other side, you've got the prejudicial effect. Is it going to create an unfair bias or just confuse everybody? And here's the key. The evidence only gets tossed out if the risk of prejudice substantially outweighs its value. So it's a high bar, but a super important one. Okay, we have arrived at the big one. The most famous, and by far the most misunderstood obstacle in this entire gauntlet. The hearsay hurdle. So what is hearsay? Honestly, just think of it as courtroom gossip. It's when a witness gets on the stand and says, well, Bob told me the getaway car was red. The problem? Bob isn't in the courtroom. You can't cross-examine Bob. You can't ask him if he's sure or if he's lying. The hearsay rule is there to keep unreliable secondhand rumors from being treated as actual facts. But like any good rule, the hearsay rule is just full of exceptions. I mean, the law has to have some common sense, right? It recognizes that some things said outside of court are actually pretty reliable. Like, what if someone screams something right in the middle of a car crash? Or what about when you tell your doctor exactly what happened to you? And these situations are exactly why the law has what are basically hearsay hall passes. An excited utterance, something you blurt out in a moment of panic, that's allowed in because you didn't have time to make up a lie. A statement for medical diagnosis gets in because, well, you have every reason to tell your doctor the truth. And the same logic applies to things like dying declarations and routine business records. They're all seen as having this built-in reliability. So, let's say a piece of evidence is relevant. It's fair, and it's not hearsay, but it still has to come from a person, from a witness. And that brings us to the next big challenge in the gauntlet, the human element. The rules don't just apply to the information itself, they also apply to the person saying it. See, a witness's credibility is always on the line, and the rules give lawyers a whole toolbox to challenge whether or not a witness is being truthful. And there is no better example of this than the legendary cross-examination by a young lawyer from Illinois. Picture this. It's 1858, and a young Abraham Lincoln is defending a man accused of murder. The prosecution's star witness gets on the stand and swears he saw the whole thing happen from 150 feet away at 11 o'clock at night, all thanks to a big, bright full moon. Lincoln lets him dig his own hole, lets him commit to the story, and then he springs the trap. Lincoln calmly pulls out an almanac for that year. He shows the jury that on the night of the murder, the moon had set hours before 11 p.m. There was no bright moonlight. There was practically no light at all. The witness was lying. His entire testimony collapsed, and Lincoln's client was acquitted. Now, what Lincoln did there, it has a legal name: impeachment. He used a single, simple piece of evidence, that almanac, to completely destroy the witness's credibility. It's a powerful tool, built right into the rules, to make sure testimony is always being tested for truth.
So as we're getting near the end of our explainer, it starts to become really clear, right? These rules aren't just arbitrary obstacles for lawyers to argue about. Relevance, fairness, hearsay, credibility, they are all part of a system that has been meticulously designed to filter information and ensure a fair trial.
And this system isn't just frozen in time. The rules are a living, breathing document. They're constantly being updated to deal with new challenges, things like digital evidence or new kinds of scientific testimony. They have to evolve to keep the system fair and relevant. So in the end, that entire gauntlet we just walked through, from relevance to fairness to credibility, it's all about one thing: creating a process that is both reliable and just, filtering out the noise to get to information we can actually trust. And that leaves us with one final big question. The rules are designed to guarantee a fair process, but a fair process isn't always the same thing as a perfect search for the absolute truth. Sometimes truthful evidence gets kicked out because it's considered unfair. So, do these safeguards for justice ever get in the way of finding out what really happened? It's a tension that lies right at the very heart of our legal system.